So good morning and welcome to Hansuke's DAC6 Academy webinar series. This is the second webinar that we are hosting in cooperation with WTS Global. Please do use the chat function on the right-hand side of the screen to introduce yourself and do let us know where you're from. Thereafter, please do comment on the proceedings for the benefit of the other participants. You can also raise questions for the panel by clicking on the Q&A button. And if you miss anything, don't worry, you will have access to the on-demand recording straight after the webinar ends. Additionally, the slides can be downloaded, and of course, the events team at Hansuke is ready to help if you wish to contact them directly for any of the materials. So, on May 25th, 2018, the EU formally adopted Council Directive 2018-822, amending the earlier directive of 2011-16 EU as regards mandatory automatic exchange of information in the field of taxation in relation to reportable cross-border arrangements. The directive, as is commonly known as DAC6, requires intermediaries such as lawyers, law firms, accountants, banks, etc., and relevant taxpayers in certain circumstances where no intermediary or professional secrecy privilege applies, to report information on certain cross-border tax arrangements to the tax authority. Those tax arrangements must be reported, which indicate a potential risk of tax avoidance. This is understood by reference to 5 categories of hallmarks, some of which need to satisfy the main benefit test. So, I am Ali Kazimi. I'm Managing Director at Hansuke. I will be the webinar moderator. I have been in the financial services industry for over 25 years, and DAC6 is by far the most technically complex automatic exchange regime of my career. Today's webinar will look specifically at the implications that the directive has on the securities industry, both on street side and buy side. DAC6 for the securities industry is particularly difficult on account of volume and frequency of transactions and the multiple number of counterparties, which makes implementation of DAC6 a real challenge. We will be looking at things like hallmarks, practical issues such as multiple intermediaries, and of course, we will discuss practical measures that firms can take to overcome those challenges. We will intentionally not look to other areas which are due to be covered by other webinars in the DAC6 Academy series. So before I ask the expert panel to introduce themselves, I just want to say that this is no ordinary panel. Before us today, we have 3 formidable tax advisors in the capital markets field. And very importantly for me, they are very close personal friends who I reach out to when I wish to discuss a complex area of taxation. So with that, I would like to invite each panelist to introduce themselves and share one interesting fact about themselves. So starting with you, Robert.
Thank you very much for the very kind introduction. My name is Robert Welzel. I'm a partner with WTS Global in Frankfurt, and I'm working in the financial service department and therefore covering asset management, financial service, securities, tax-related topics, etc. This year, no holidays. Usually I go trekking. This year I sit in the office.
Perfect. Thank you very much. And with that, I would like now invite John Billige of State Street.
Good morning. Thank you, Ali. John Billige, I'm the EMEA Operations Tax Director for State Street Global Markets within the London branch of State Street, also covering the London branch of GmbH. One of the things I did up to recently outside of work was compete, at the equine level. I was a horse owner and was quite successful at some events and also trekked across America on a horseback, being a cowboy for a week about 10 years ago.
And how is Goodwood for you this year?
Good. I don't actually follow horse racing, I'm afraid. If you're talking about the Goodwood Festival of Speed, I think that's been, I think it's been cancelled.
And last but not least, can I invite Gavin Helmer of Hansuke?
Thanks, Ali. Yes, Gavin Helmer, working now with Ali at Hansuke, previously in a number of different banks, dealing with a number of these issues that we'll talk about today, through an evolution of various regimes, both in the UK and Europe. Actually, on Robert's point, I between Credit Suisse and Hansuke, I had an excess of holidays. I've never had so much time off and enjoyed it thoroughly. But what's keeping me most busy at the moment, actually, funnily enough, is my work for a charity. I won't do a plug for that, but of course, COVID bringing a lot of problems to the charitable sector, and I work as a trustee for a charity dealing with donkeys and working animals. So that's maybe a vaguely interesting fact about myself.
Yeah, some of us all get to work with donkeys at some stage in our careers. So, with that, Gavin, what do you think are the main external governance considerations when it comes to applying DAC6 in a capital markets securities industry?
Yeah, thanks, Ali. I mean, you know, not to repeat too much what other people may have heard on many webinars on this topic, but this is all part of the ongoing tax transparency agenda from governments. If we just think in the wider context, we have FATCA and AEI now reasonably well embedded in all jurisdictions, and that's their combat tax evasion. We have both regulatory requirements, but also specific legislation in the UK, for example, the UK corporate offence to combat facilitation of evasion. So we've got those regimes which are dealing with the illegal activity of evading taxes. We've had, again, focusing a little bit on the UK, but we've had regimes which deal with improving compliance and increasing transparency, thinking of the Code of Practice for Banks and the Senior Accounting Officer regime. But again, in other countries, you could find similar types of regimes that have come forward. Now DAC6 has come along, so where are we at? Well, governments are heading obviously much more towards the tax avoidance agenda. And DAC6, leaving aside maybe Hallmark D, is focused on tax avoidance. And the desire of governments in Europe to be able to obtain information, so greater transparency, again, transparency agenda, obtain information on potentially aggressive tax planning, but as we'll discuss today, maybe will capture a lot of things which don't really speak to or deal with aggressive tax planning. As Ali says, a highly complex regime. DAC6 is, you've got to think about it both from the sort of proprietary perspective and the client perspective. You have a number of issues to work out, very subjective, work out a number of issues in terms of what's an intermediary, what's cross-border arrangement, reasonably expected to know standard. Again, we're going to cut some of these things as we go through. But in the widest sense, you know, the external landscape is one of ever-increasing tax transparency, governments and tax authorities wanting more transparency. But also in many of these regimes, you know, just important to note, I think they're hoping to alter people's behaviors. So DAC6 ostensibly is just to report information to tax authorities, but I think more than just one or two papers make reference to the fact that I suspect governments are hoping that it will alter behaviors of intermediaries who are in any way, shape or form involved in this type of activity or what they perceive to be aggressive tax planning, and start to shift people towards what they want to be a more compliant landscape, not entertaining the possibility of helping people to aggressively plan around their taxes.
Sure. John, I mean, you know, a couple of years ago, you were implementing FATCA CRS. Is just one step beyond?
I think so. Yeah. The main I think issue with DAC6, it sort of introduces a level of transparency where you sort of required possibly to look through a chain of transactions, which is if you were to say look at what a borrower is doing with securities borrowed from an agent, you just don't have that. And so I think that the sort of environmental level, it's changed the market from that point of view, where you could possibly have that requirement to look further, which is not sort of available really.
Excellent. Before I go to the next question, I mean, Robert, do you want to add anything from a German perspective? I mean,
Yes.
Gavin mentioned the sort of like early warning, just a game changer. Would you say the same thing on continent?
Definitely, yes. Probably even from Germany, you will receive even worse news in this respect of transparency. It started with a, let's say, a feature to detect aggressive tax planning, but it really emerged, let's say, that the tax authorities, especially now the, let's say, the regional tax authorities, they clearly expressed their understanding, and what they are looking for is to gather as much information as possible via this directive and the implementation of this directive. So the broadening of the transparency which really emerged is very substantial here in Germany. And it was has been clearly articulated by high officials. Their intention is that they gather as much information as possible, so that ultimately tax audit, etc., will increase the level of quality for the audits. Let's say very often the process to re-engineer the trades and the underlying rationale, so that this is very obvious to the tax authorities, and they can go directly after, let's say, testing whether from a technical point the conducted trades are valid, yes or no.
Yeah, thank you very much, Robert. I completely agree with that. Let's dive, straight in to some of the hallmarks, and we will talk a little bit about what the trade associations have done. But before we do that, I would like to just independently look at some of the hallmarks, particularly as they apply to the securities industry. Now, the first one is A2 on contingent fees. Now, there's been a lot of debate and discussion, and if I can ask John, I mean, sort of like, I was somewhat surprised that there was so much discussion. I would have thought it didn't require that much discussion. What are your views?
I think initially when we started to sort of look into this and the construction of how stock loans are priced, the fee is obviously part of that pricing, and this is what they call sort of the all-in rate, which is the dividend value and the fee. And I think initially there was a lot of concern that that fee was driven by tax motivation, because it's based upon the dividend value. But as we've sort of gone through this and discussed it more, we sort of put the fees into a couple of categories. If you were to transfer securities, say French securities, for example, to a French borrower, and you don't know what the borrower's doing with those securities, they hang on to them over record date and then pay you a manufactured payment, for example, inclusive of the fee. There's no way of knowing whether that fee was derived or has derived from some sort of local tax advantage they may have got at the corporate level, so it's sort of unknown. So those areas we sort of saw as probably more riskier to deal with than situations where you would be, for example, lending, say, French equities to a non-French borrower, or say a London branch or a London counterparty, who would be covering short positions and hedging with a derivative, where the income to pay for the borrow of the securities, is not sourced in the jurisdiction of the issue of the securities, is separate to that. So I think that when we looked at fees, to try and put into perspective a little bit, we looked at the sourcing aspect of them, where they come from. And that sort of, I think we got to, my understanding industry level, we got to sort of some comfort level that, that shouldn't necessarily be a problem unless you had an absolute reason to know that there was something spurious around the transaction. Yeah. For example, the fee was very heavily priced into it, well above the gross dividend value. I mean, that would be a clear indication something's going wrong. So that's sort of what we sort of looked at, Ali, from the point of view of where do we have sensitivities around the potential risk that fee could be driven from a tax benefit.
Okay, thank you very much. Robert, Gavin, do you want to comment anything further? Or? Okay, I'll move to the next one, which is about, again, I think a bit of a red herring, which is around standardized documentation. I think the stance is somewhat different. I know the industry bodies and the debate over here has come to, at least in the UK market, come to a pretty easy position. Robert, that's not the case in Germany, is it?
Let's put it this way. What we see, the industry associations, they talk a lot about standardized documentation. Standardized documentation as such should not be a problem in a lot of, generally speaking, but the German understanding reflects not only standardized documentation, but also the understanding that it covers standardized structures. And if you, let's say, look at trades, how they are conducted, it is very easily to replicate them. They are set up in a standard fact pattern. And so these standard fact patterns, which will be easily replicated for a lot of times, which are for all the involved parties. And if these features or if these standard patterns cover or addresses, let's say, tax optimization, then it is very likely that they will be covered by this hallmark. And if you have the sufficient knowledge as an intermediary, you know the counterparties, you understand probably the intention of trade desks, etc. It is a topic to be addressed and to be looked at in more detail.
John, do you care to comment on that?
The work that I think the revenue's point of view about sort of standardized documentation, they're still not sort of entirely clear on it. I don't believe, the guidance notes are sort of a bit loose on that point, but I think in the UK, the general view is that, again, unless you have absolute reason to know that the transaction under those agreements, for example, the standard GMSLA or GMRA, is being specifically used for tax purposes, then you would report. But generally, those agreements, are not designed to provide tax benefits. They're designed to put the lender in a position from an income point of view as they would have been had they not lent the securities. So there's no sort of they're not like a tax motivated promoter document as such. But to Robert's point about Germany, we found that, and I think that the German Ministry of Finance in their draft administrative guidance sort of saying that the GMSLA or the GMRA or the ISDA or the LMA, for example, are standardized agreements. And that's the end of it. Robert, that's pretty much what you were saying, isn't it?
Let's say they are standardized agreements, okay, but standardized agreements per se are not, let's say, if they are covering, let's say, the typical business arrangements for financial instruments, they are, let's say, they will not trigger automatically this, the hallmark A3. But let's say these documents are part of, let's say, an overall structure which very often is quite obvious or could be obvious, and that's then the topic.
Sure.
Typical text-driven structure. So we are really talking about here the subsector, not the general business for securities lending, etc., but how to capture, extract typical text-driven trades. That's the issue.
Yeah. So you could have multiple hallmarks, but just looking at this particular hallmark, A3. That does not in itself, generally, I think the market position is, whether it's the GMRA or the GMSLA, OSLA, whatever you might be using, including the ISDA, by the way, sort of like, because the schedule gives that bilateral element. Generally, the view is that should not in itself be suggestive that it's a standardized document.
Okay.
And I think the other thing is there is the MBT shield, which we will talk about in a minute. So I think generally most of the market is in a safe place as far as the documentation is concerned. Can I, Robert, just staying with you, talk a little bit about recharacterization, which is B2. That has received a little bit of interest, but I would be interested in understanding how that is being applied across, in Germany.
Let's put it this way: from being a tax advisor for quite some time in and what we conducted at the end of the 90s and throughout the last 20 years quite often is, let's say, how to recharacterize taxable income in tax deferrable income, etc., especially via financial instruments. You have the opportunity via the financial instruments or derivatives, etc., swaps, really to autonomize, let's say, the value chain and put it together in a complete different way. And this is exactly, let's say, in case of dividends, but with underlying, let's say, on the other leg, total return swaps, etc., very often an issue. So the recharacterization also interferes with the overall concept of, let's say, ultimate beneficial ownership, and so on, and therefore, let's say, or circular trades here, we are up to a certain degree we will cover too, and that is absolutely definitely a topic here.
Great. And on the recharacterization, I mean, I always think about this, John, from the perspective of what you're doing is, this is old tax alchemy, whereby you take income, turn into gain, and vice versa. But, to the extent that you've had measures like 871M dividend equivalence, as tax authorities move down towards essentially maintaining the source and character of the underlying, which cannot be recharacterized through the use of a loan or a derivative instrument, we should be fine, shouldn't we?
Yes, you see jurisdictions, as you say, like the US, that impose on anyone paying a substitute payment anywhere in the world that is a US source dividend effectively. And that's sort of the same as Switzerland as well. When they're paying out their manufactured dividends, they're considered to be sort of a real dividend from a Swiss point of view, that you could access the treaty to recover any of the 35% withholding. And we're seeing it, I guess, as well in Germany to some degree with the GITA 2018, where the manufactured dividend value has a tax attributed to it now. It's still sort of, I think, categorized as other income, but there was some debate as to whether or not it should retain the character of a dividend. When we're looking at recharacterization itself, saying from an agency perspective, I think one of the most important things is to make sure when you're acting on behalf of a client where you're running a discretionary lending program on their behalf, that your due diligence around what you're paying them is actually sort of doesn't create a tax issue for them in relation to the fact that if they were to hold a real dividend, they would be taxed on it, but if they were to receive a synthetic, they wouldn't. So a lot of the due diligence, all of the due diligence that we do, is making sure that if there were to be a change of character, that the tax effect on the client is no different to that they would have received had they got the real dividend. But I think to the point that we're seeing with Germany at the moment, where you've got the lending going on there, particularly for asset manager clients, where the income is not considered to be a real dividend or interest that hasn't been subject to withholding. There are some concerns there, I think, about how the Germans will deal with that from a reporting point of view, to make sure there's no tax advantage to the lender because of that recharacterization change.
Yeah, I mean, this is a really interesting area because I've been working with some funds lately. I mean, we saw this with Fin48, now with IRFIC coming in from the start of the year. I mean, what you've seen is essentially where people have used, say, for example, synthetics, particularly to make it advantageous from a stamp duty or capital gains perspective, those kind of recharacterization trades, single stock futures, are just going to be very, very difficult. Before I go to the next, I will go to the next session, just conscious of time, is B3, which is about circular transactions. Now, Gavin, we've seen this before, haven't we?
Oh, absolutely. Yeah. I mean, the circular transactions have been a bugbear of many authorities for many years in relation to many kinds of activities. And here, I mean, again, focusing briefly on the UK, the whole Ramsey principle of interposed steps lacking any commercial purpose. So I think maybe also just digressing briefly, worth remembering at this stage that we're dealing with 26 different jurisdictions, or many of you may be dealing with multiple jurisdictions that may interpret any of these, if we like to call them red herrings, in slightly different ways. So what is circular transactions? I think that's, I think we all know what they're trying to get at, and the UK guidance makes this reasonably clear. It is transactions which have some sort of feature where there is something interposed which has no commercial purpose, self-cancelling transactions, again, without much commercial rationale, all underpinned, though, don't forget, by the main benefit test. So it would be easy to maybe dismiss this as a red herring or something which is maybe in the too difficult pile. But it is, I mean, John will come on and maybe turn over to John in a second to talk about basic collateral transfers and how they might be assessed. But it is something that needs to be borne in mind. Again, with probably an assumption that most of us know what they're trying to get at, where it was round tripping of funds, and it was highly leveraged round tripping of funds, so moving funds between counterparties 4, 5, 6 times to leverage the tax effect of something. But like with much of the rest of DAC6, possibly overshooting and possibly landing us in this situation where people might feel they have to report perfectly benign transactions under this circular transaction hallmark. Yeah,
I mean, it's interesting because when I read this, particularly with the securities industry in mind, I generally felt the circular transactions should have really been given a lot more attention than perhaps the trade associations gave it. And we will come to the trade associations later on. But, John, if you could elaborate as to how an important hallmark it is, which needs careful consideration.
Yeah, to Gavin's point about the taking of collateral securities, there are two models in the market really. A full title transfer, which is primarily used in Europe, versus a pledge that's commonly used in North America, but sort of has been introduced certainly through ISLA for use for market participants. The pledge sort of makes life, I think, a bit easier from the point of view of where does the beneficial ownership reside on the securities, although it's not entirely clear, I guess, in some instances. But with the title transfer, I think it becomes more difficult, and it can become more difficult. And the market practice is generally to substitute before an income record date. And there's a lot of use now of tri-party, where sort of institutions would appoint a tri-party collateral agent. And the interesting fact there is that when you're looking at can that collateral or a taking of collateral be considered like a corresponding transaction? So you are effectively swapping your loan securities for collateral that could give you a better upside, and you hold that collateral over record date. Well, it would be unusual, I think, for a lender to retain collateral sort of equities, for example, over record date, but it can happen. But to sort of say that, I think, is taking of collateral sort of a corresponding transaction or circular. When you look at the practical aspects of how a tri-party agent operates, I mean, the lender would appoint them to manage the tri-party collateral for them, and basically it's the borrower and the tri-party agent that manage it daily. I mean, based upon the authorizations given to the tri-party agent by the lender, and they're sort of disconnected in a way. For example, when we take a loan on the agency side at State Street, we pre-collateralize first, and then the loan goes out afterwards, but they're not actually connected. It's just a value that we've got in with a margin, and then the loan can be released. And the securities taken in don't always stay the same forever. I mean, absolutely. I think one of the JPM, for example, could be wrong, but recently did some work on that side a few years ago. They would rebalance the collateral position around every 20 minutes. So, but the collateral would be relevant to what the lender has asked the borrower to give within the approved authorizations for either themselves or on behalf of a client. So that sort of disconnect there, I think, takes it away from it. Is it a circular transaction? You could argue clearly that it isn't because of the way it operates. But if you were to take it bilaterally, there could be more of a, maybe a structure around that or a different motive. But generally, taking a bilateral collateral it does happen, and we do it. But generally, we prefer to use tri-party. And holding over record, as sort of mentioned earlier, if it's a full title situation, does the lender get access to a treaty, or could they get access to a treaty? It's debatable. Or would the jurisdiction in question default to the collateral giver to say, well, actually, no, you're not the beneficiary, only the borrower is. So in order to avoid those circumstances occurring, so substitution is relevant, but it's not to say that you could use that type of process to procure a tax advantage. Yeah,
I mean, my concern isn't what is the right answer. My issue was really around the process. I think, sort of like John, as you point out, the collateral transformation trades, which law you're transacting under. Is it New York law? Is it security interest has been created or not? And particularly the area of rehypothecation hasn't really been properly looked at, which should have probably been under the B3 category. And, we'll come to, as I said, the trade association's role in this, because I think omitting that has kind of just brushed over the thing. Now, one protective device that, the industry has is the main benefit test. And this is rightly so, sort of like, given that we are dealing mainly in the sort of like categories B and C, A, B, and C, it is very important. Do you want to comment on that? I'll start with John, if I may.
Yeah, I mean, the main benefit test is really where, certainly following the UK guidance, that's where the reason to know comes in. If you have, as a service provider, as opposed to being a promoter, an absolute reason to know that the transaction in question or the CRS self-cert, for example, that you're receiving from a client on the onboarding side is something wrong with it, or you have a reason to know that there is a wider tax motivation behind it, is a sort of, I guess, helpful in a way, because the idea there is that your BAU, you have to be able to demonstrate that it isn't driven for that purpose, but it isn't designed for that purpose at all. So having knowledge of something odd going on would be in the minority, generally, I would have thought. But it could happen, and there could be a reporting obligation. But Robert and I were discussing before the panel session started about, we've come across with Germany, for example, that the main benefit test could even be triggered just by the fact that you've received a manufactured dividend or manufactured coupon interest without a withholding on it. So it sort of takes the decision-making process away, I guess, and just says, well, you're receiving 100%, so you're obviously up to something no good. Robert, maybe you'd like to comment on that.
Just before I go to Germany, can I just ask of Gavin, I mean, where is HMRC on this? I mean, they mentioned policy intent, and also the abuse. Do you think HMRC has been overly relaxed about this?
No, I think HMRC have in many cases in these kinds of global multinational regimes shown themselves to be pragmatic from a policy perspective. I mean, maybe the detailed implementation that doesn't always bear out, but I think their position is not overly relaxed. It is recognition of what DAC6 is intended to do, and I think in my experience, HMRC are reasonably good at expounding on what their policy intent is. And the policy intent of DAC6 is to capture transactions which are egregious and which have a a tax avoidance motivation, and not to capture transactions which are within the policy intent of a legislative framework. Now, of course, that can be incredibly difficult to work out. The main benefit test may in practice be very, very difficult to work out. Highly subjective. Is it the main or is it a subsidiary benefit? But as a starting point, I sort of commend HMRC's position that what they're trying to do is capture or have intermediaries report on transactions or arrangements which are contrary to what tax authorities intend. Because if they're not contrary to what tax authorities intend and they're reported, it just becomes a lot of information in the hands of tax authorities that then doesn't really serve any purpose to them. They want to focus in on what's egregious and what they ought to be focusing in on from the perspective of using DAC6 to then combat aggressive tax avoidance, to change legislation, to change the way the tax system works, so that that kind of abuse can't continue.
And I think HMRC are more focused on promoters than service providers from that perspective.
So Robert, are the Germans being overly pedantic? Not Germans in collectively, I meant the
probably yes, and that's correct. I'm here the bad guy, to put it this way. As indicated, HMRC, you outlined, probably they are really still focusing on the original intent of the DAC6 directive, whereas Germany now, it is not only looking to understand, let's say, tax features of aggressive structures or even avoidance or abusive structures, but they want to understand what is the, let's say, tax advantage, even if the tax advantage is completely in line with the tax regulations as such. So this gives this provides for a different angle, and also from a different, provides for a different perspective on the MBT, and therefore it will really broaden the scope of reporting topics. So it's not only the main benefit, it is one of the main benefits, and the main benefit is tax, let's say that you have some sort of tax advantage, whether disregarding, or it is not of importance whether this tax advantage is based on tax aggressive planning or yes or no.
Okay, thank you very much, Robert. Shall we turn our attention, I mentioned earlier on the role that the industry associations have played. And I know, Gavin, you've seen this closely. I mean, there is obviously sort of like ACME/ISDA did their work to start off with, and then ISLA came up with their paper. I mean, has it really helped the industry?
It's interesting. I mean, of course, on most new legislation, most new regulation, there will be an element of industry representation. I think on DAC6, given some of the difficulties with the interpretation, you know, we all know how DAC6 was essentially rushed through the European Parliament, and therefore it's come out as you know, less than perfect in terms of what it's delivering to people from a compliance perspective. But we therefore saw ACME particularly, I think, initially trying to get some tax authority confirmation on how certain things ought to be interpreted, whether certain transactions ought to be reported. And of course, most people will know that if you ask a tax authority, generally, if you ask a tax authority to confirm something, they're going to come back and say, we can confirm that's okay, unless it's not okay. So that they'll do an element of fence sitting, because they don't want to be pushed into a corner. I think Keith on one of his chats has used the word paranoid. I think tax authorities are generally paranoid that if they ever give any kind of certainty on a new regime, which is intended to require some judgment, that people will arbitrage it. So simply put, I think particularly the UK authority, a lot of evidence over the last 20 years that they are very paranoid about people arbitraging anything they say. So if they give any clarity on anything, that people will get in there. So ACME, I think, eventually landed up writing a reasonably good, reasonably helpful paper, sets out 5 principles under which they are basically telling putting tax authorities on notice, we will operate under these 5 principles. And if we operate under these 5 principles, we believe that we should be okay. I won't go through those in detail. The first one, I'll just start with the first one, but not really go through the others. But for example, they put down a principle that people ought to, or intermediaries and service providers may be able to rely or be able to rely on reasonable procedures. And in a regime like that, that's very important. So that's to say, if we act in good faith, if we put procedures in place to try and on a best efforts basis and in good faith to capture the kinds of transactions that you want us to report, in effect, you will, as a tax authority, you will not take it too harshly on us if we fail occasionally to report. That's the essence of what they're trying to say. If we have reasonable procedures in place, let's all agree that we've done what we need to. So there are 5 principles in the ACME ISDA paper. Again, whether, Ali, to your question, do they achieve much? Well, I think they do. They do put tax authorities on notice that that's how the industry is going to apply it. If everybody in the industry then does apply it that way, then tax authorities might struggle to argue that's outrageous. But no tax authority is going to be bound to anything that ISDA say, ACME and ISDA say in their paper, because any tax authority will be free to say, well, we disagree that that's how it's to be interpreted. Yeah. And by its nature, what ACME and ISDA have said is in some parts also a little bit, I think it's good, but it's a little bit woolly in parts. I mean, what is reasonable procedures may differ from taxpayer to taxpayer. I'll maybe ask either Robert or John to talk about the ISLA paper. That's just my thoughts on the ACME ISDA one.
Yeah, I agree with you. I think the core principles did help me at least sort of like advise clients, and it does establish and put the tax authorities on notice. Now, having done that, I mean, John, I'm going to just ask you, what was the point of the ISLA paper?
Well, I think it's helpful to the extent that the industry body wants to sort of use that paper, not just to send to the UK revenue, but also to other tax authorities establishing, where the industry stands with its members. They're sort of, the paper's consistent with the view around sort of fees, pricing, main benefit test, and confidentiality and standardised agreements, along with ACME and the UK finance submissions as well. So I think that the industry bodies need to do something, and they have, and I think that it's certainly from the work that we did with UK finance with HMRC that they were sort of really quite appreciative of the amount of information that the industry was giving to them, because that's, I think, what they wanted. But I think one of the things that came out of those discussions and dialogue through those industry submissions has been HMRC's view that you need to introduce training, you need to introduce an escalation process, and take some of the say, for example, non-tax trained people dealing with difficult matters or uncertain matters, and pushing that into sort of SMEs where they can look at the situation and make a determination whether something will be reportable or not. So I think that the industry submissions along with that dialogue helped us to sort of understand that better from an HMRC point of view. As a service provider, if you can introduce that, it's quite a way to go to get some sort of sound governance behind administering DAC6.
Mm-hmm. I mean, it's interesting that I think generally the view has been that the ACME paper was probably a bit more useful than the ISLA one because there are some limitations there.
Yeah.
No, I would encourage anybody on the call today who hasn't read the ACME paper to have a look at that. I think the 5 principles are worth looking at carefully in the context of what you might or might not be doing for DAC6 implementation. And it is a sensible, commercial, practical approach that if tax authorities buy into, should see you in a good position.
But I think as well, the ACME paper was covering a broader spectrum.
Yeah, very true. Very true.
Whereas the ISLA paper was just sort of pretty much looking at transfers of collateral and temporary transfers of stock lending positions. So, and then the UK finance papers that were put together did include a stock lending paper. Yeah. So I think that the trade associations have responded with with information about or about the breadth of transaction types they're covering.
Yeah, I mean, my concern was like the ISLA paper didn't go far enough as far as B3 is concerned, which we discussed earlier on. And the other thing is the desire to circulate the paper to all tax authorities. I'm not sure that is a good judgment call, just particularly in light of the recent EEBA paper.
Yes.
So,
I think that EBA paper has demonstrated how even competent authorities themselves are unclear what's going on.
Obviously, Germany has been at the forefront of this, Robert. I mean, with the COMEX and the CumCum sort of like thing. Would you like to comment on where are the tax authorities in terms of their how relaxed they are, how apprehensive they are at the moment?
Yes, I think covering these papers or the FME and the ISLA paper, you are much more competent to comment from a UK perspective, but also from the German perspective, it's my personal understanding it provides for a good starting point to discuss all the topics, really what is in, let's say, what are the industry, the trades, etc., and what is prudent governance. And they also address if there are very bespoke tax topics, etc., you have to take probably additional view and think about it for your own setting up your governance, etc. And that's it also. And there, let's say, putting this together with dividend arbitrage and all these point of views, if you get knowledge and if you know and if you facilitate somehow these, let's say, very tax-driven structures, then you are not conducting typical general, let's say, business. Then you have to implement additional features for transparency reporting or even not conducting these trades. I think there you find within these papers already a fine or somehow already addressed.
I'm just going to turn to Gavin. I'm just conscious of time, Gavin. This issue of, you alluded earlier on to reasonable procedures, and, in the case of intermediaries, I mean, sort of like, short of being a, full-on promoter, I think sort of like the case of the service provider category intermediary is particularly problematic, particularly because they have the knowledge test. Can you sort of like just elaborate on that, please?
Well, sure. I mean, actually, I'll also pick it up in the context of the ACME representative paper again, which is their second principle, which is titled Limited Knowledge Acquired in the Course of Ordinary Business. So the idea here, and this is backed up by what the UK tax authorities, but also other authorities have said, which is there, and the directive itself, I think, on some of the guidance around the directive, which is there isn't really an expectation that you have to go over and above what you're required to do already from a regulatory perspective or from a client onboarding, KYC, or all sorts of other perspectives, and from a internal procedure perspective to find the ultimate Old Testament version of truth about what every single transaction relates to. So put simply, you should rely in large part on existing processes, existing procedures, policies, which are designed to capture, again, maybe for regulatory reasons, behavior by clients which may indicate money laundering or tax crimes or other things. So I agree, Ali, that it on the surface it looks like it could be very difficult. I think one has to take a pragmatic approach. One has to look at the guidance. One has to take a position, organization by organization, as to how far your existing procedures cover you from that perspective. And again, in the context of the first ACME principle, reasonable procedures, do you have reasonable procedures that you can evidence that for this set of transactions, there was no reason why you should know more than you did know. But for these, of course, you did have that knowledge, and therefore you did report. So it's maybe another minefield, one that needs to be appropriately.
And Gavin, if we step back logically, what were the tax authorities even expecting under this thing?
It's not. Don't forget, again, this started in the European Parliament. So I think what was the expectation? The expectation that, or I dare say cynically, that you could say that they worded it in such a way that they could argue it any number of different ways that you should have known, should have been reasonably expected to know that this was egregious tax planning, even just as a simple service provider. And again, ACME and industry representations looking at loan transactions, for example. Yeah. Well, in the ordinary course of lending, I may or may not, depending on the regulatory regime and the size of the loan and the maturity and everything else, I may or may not need to know exactly what you're doing with the proceeds of that loan. If, as part of my procedures, I'm required to know what you're doing with that loan, and you tell me that it is to be used in the context of a tax planning transaction, maybe then you've triggered the requirement to then investigate further and then potentially report. So it's a very complex area, but one which, again, approached in a structured, methodical manner, I think you can get through it and come out the other side with those reasonable procedures, which provide a penalty defence in case tax authorities challenge you and say, well, you should have known.
So in the context of the capital markets industry, I mean, John, if a house does decide to take a overly cautious approach, I mean, is there a risk, because you've got, say, for example, a loan going through the market, that it just requires one person in the chain to have the threshold risk appetite to be so low, there is an element of over-reporting, and easily we could fall into that trap?
Yes, you could. I think from a service provider point of view, the first thing that you need to really have in place is an impact assessment on your products. Looking at what they are there for, what they do, what they achieve, and what they provide, and generally, from our point of view, they're not tax-motivated arrangements. So you know that your BAU should be okay, but there are those situations where you could take the view that okay, we're good with that, but you lend your securities, as you say, down the line, and something goes wrong. You could have a promoter that claims legal privilege and it shoves it back to the client that you're acting for, and the client could come to us and say, oh, look, you're the intermediary that I was managing for me, could you do the reporting for me on this particular subject matter? I'd say that's quite low risk, but it could happen. Or there's the other situation that I think worries me more, is the fact that again, that there could be a promoter further down the line that we can't see, and the whole chain is divulged because, as revenue say, they want to see everything. They just don't want to see pockets. They want to get the whole picture in the round. And then you find that you become reportable as an intermediary, as part of a chain that you didn't expect to be caught by. So internally, in order to help manage that risk, as I said, you have to, good impact assessment, and also introducing an appropriate escalation process where people can escalate the concerns, even suspicions they may have about something, because at the end of the day, the reporting aspect of this is within 30 days of knowledge or 30 days of implementation. That's a really, really short time frame to do something. So what we've done, is introduce every month. The business has confirmed to us that they've not seen anything, but it puts them on notice that you've got a 30-day window, that if you do see anything, tell us immediately. Then we repeat that every month, and that is trying to introduce a reasonably sound governance process around making front office people or onboarding people aware that there is a protection mechanism for them, and there is an escalation process that they can go to shove the problem up to SMEs, where it will be hopefully dealt with within that period of time. And you could contest the fact that you have to report anyway, and that's what we need to be able to do, is to have that strength of saying, we disagree with you, or okay, we agree with you, we'll report,
And I think that's the challenge. It's actually the internal protocols is one thing, but it's when you've got counterparties, multi-counterparties, I think that's where a lot of the work needs to be done.
Ali, since we've asked for audience participation, there are 2 or 3 questions maybe in the last 5 minutes we can cover off. I know we haven't covered everything on the agenda, but I don't know if we want to just cover Liam and Keith's questions there. Maybe if I'd kick off with Liam.
Please,
yeah, no, I mean, Liam, yes, that is very interesting. I'm not sure how many taxpayers will take that position. I think there's an interesting interplay that we haven't discussed in any detail on GDPR, which people get very concerned about, whether over-reporting then breaches GDPR regulations. But I think it is very interesting to ask the question, if tax authorities do get bombarded, what are they going to make of it all? I don't think it shouldn't be the case that it will be routine transactions as opposed to aggressive, because if DAC6 works, they should get, if people over-report, they'll over-report both on the routine and the aggressive side. So you would think the tax authorities will, in amongst all the massive information they get, have the aggressive stuff. And I think much like other reporting regimes, the key question is, well, how much resource do they have? to be able to deal with this stuff and to be able to interpret it. And of course, maybe it's exaggerating, but DAC6 seems to have in some ways gone a little bit quiet on the government side because there are more pressing matters, Corona and the impact of that. And I think one of the things we were discussing yesterday as we had a quick chat in advance of this is what does it look like in 3 years, 4 years, 5 years time when tax authorities have started to interpret data? Are we going to see them with a massive changes to the legislation to try and cut out abuse? Or are we just going to see that they don't have the resource to analyze this and interpret this, and they hoped maybe in part that DAC6 would act as a deterrent? I think in some ways, much like FATCA and AEI are for some tax authorities a deterrent tool, and they don't have the resource and the time to look through it all. So I think your question is actually one that's very difficult to answer in less than about an hour, but I think it's an interesting one.
I think it's going to be probably down the DOTAS route, whereby it becomes an early warning signal, which then basically deters behavior, changes behavior. So we've got to where we started off with. I've just got 4 minutes. I'm going to ask you within 40 seconds each, what are the real key takeaway points and bullet points, please? Starting with you, Robert.
Yes, I think to analyze, let's say, within your product portfolio or with your clients, to have a methodology to extract text-driven features, and then to analyze whether they are reportable yet or no. And this could be, let's say, from an analytical point of view, we are talking about text-driven. Very often, let's say, for dividend trades, it's around the dividend trade day. What are the trade patterns, etc.? Who are the counterparties, etc.? And so on, to analyze this in detail a little bit more. And I think then you very often will have already the opportunity to extract relevant trades.
Thank you. John?
Dialogue, internal dialogue, escalation process, impact assessment, speaking to clients, informing them of your internal governance process, so they're aware of what you're doing, because a lot of clients don't necessarily sort of fully understand what's going on here from a DAC6 perspective. And supporting the business and working with them to make sure that things, should they crop up, are appropriately escalated and supported.
Indeed. Gavin, any final thoughts?
Sure. I mean, from all my time in banks, I'd always approach this from the perspective of a risk management question. Well, what are the risks we're trying to mitigate? And in DAC6, I think it's penalty. Financial is penalty risk, and then there's the reputational risk. I think to John's point, to Robert's point as well, there's no substitute for taking DAC seriously, but doing it in a structured and methodical manner, and coming up with something that is ultimately going to protect you if you don't get it right 100% of the time from those penalties and from that reputational risk. Like with any other regime, if you do nothing and just hope that you're not involved in this sort of stuff, it's not going to look good if it goes wrong. If you do a reasonable amount, and again, I use the word reasonable, which is in the ACME principle one, if you put in reasonable procedures, it's difficult for a tax authority then to be too difficult or too stringent on you, and difficult for your reputation to take too much of a hammering, I believe, because you can evidence that you acted in good faith and you did the right thing.
Yeah, I think that's probably sort of like a good point to stop the discussion, the panel discussion. For me, I mean, the operationalization is always the difficult, when it stops being a project and you have to live with it. And if you haven't built the enduring structures, that's going to be a problem. But thank you very much for a really deep, insightful conversation to our panelists. Thank you very much. Do continue the DAC6 dialogue with us. We at Hansuke, in collaboration with our partners, are leading the DAC6 discussion for the financial services industry. Next week, we will be speaking to a technologist talking about how DAC6 fits within the RegTech ecosystem. So a prompt has come up, so if you wish to register for that webinar, please do so, and continue dialogue. And I wish you a very safe week and good luck. Thank you. Goodbye.